All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. This is the time set for oral argument in 1 CACV 230398, Stacy Martinez et al. Versus Hubert Blake. As a reminder to council, this hearing is being video and audio recorded, and in a few days the video will be posted to our YouTube channel. Before you begin your argument, please identify yourself and the party that you represent. Each side will have 20 minutes. If the appellant or the cross-appellant would like to reserve time for rebuttal, you're welcome to do that, but you're responsible for keeping track of your own time. We have read the briefs, conferenced the case, so we are familiar with the issues. There's no need to repeat what's in your briefs, but you're welcome to proceed.
Thank you, Your Honor. May it please the court, my name is John Mazzacchio with the law firm Goldberg & Osborne, and I represent the plaintiffs, appellants, / cross appellees in this matter. I would like to reserve 5 minutes for rebuttal, please. Ignorance seems hardly the goal to set for the landlord. That statement was made by this court in the 1972 case, Preston versus Mountain State Properties. And that has been the overarching principle applied to short-term leases in Arizona ever since, for the last 52 years. The duty set in that case makes it clear that unlike in traditional, long-term, 1 year or more leases, the short-term lease puts a duty on a landlord to ensure that the property is safe throughout the short-term lease term. My clients, yes, Your Honor.
You anticipated my question. So what is the legal duty? What duty does a landlord owe to a tenant when it comes to a dangerous defect?
Well, there are a few duties. One is the duty to make sure that the property is reasonably safe. Another is to inspect it for that purpose.
Inspect it when? Before the tenancy begins?
Well, that would be the case for a long-term lease. Certainly, for a short-term lease as well, it should be inspected, shortly prior to the tenant taking occupancy. But Preston makes it clear that the landlord's duty is continuing to make sure that the property stays in good condition throughout that short-term lease.
I'm not sure I'm following, though, the distinction you're drawing between a long-term or a short-term lease where it's a month-to-month lease and the tenant lets the landlord know 2 weeks in, I'm going to stay another month. You're saying the landlord has a right to go in and inspect after the month? Usually landlords are not supposed to go in unannounced, or they would have to ask permission. A landlord has to do that on a month-to-month lease if the tenant each month says, I'd like another month, 2 weeks in.
Well, Your Honor, my understanding is that that is a continuing duty. And in this particular case, the landlord admitted that he was on the property repeatedly. He admitted in his own testimony, which was ignored by the trial court, that he was looking at things on the property the entire time.
But is your argument that based on that he should have known that there was a problem with the step?
Yes, in part. We believe that he should have known.
But what's the
And
best
if-
evidence that he should have known that the step was defective?
Well, that would be his own testimony coupled with photographs of the steps.
His own testimony of what, though? What specifically about his testimony?
Well, he testified that he knew that he needed to maintain the steps, knew that he needed to check the steps because, in his words, varmints would nest in there and make problems. These steps were also more than 20 years old and subject to snow every year in the northern part of the state with repeated, wear and tear. One other important fact
In
also.
terms of evidence that was presented, what was argued that this is the evidence that he should have known that there's a problem with this step?
Well, that evidence was his own testimony, saying that he knew that he needed to check the steps. He knew that he had previously made some repairs on the steps and the porch.
Weren't there repairs to the handrail? Was that different than the step?
Well, he was wishy-washy, I'll put it that way. And he was very inconsistent throughout his entire deposition testimony. Based on all of that testimony, though, those inferences, and there's a dispute as to what his testimony actually means and what the words he spoke and are printed on the page actually mean. And the inferences drawn by the trial court were obviously not in my client's favor, but those inferences should be for a jury to draw, not a trial court judge. And I've provided in my submissions entire passages from the landlord's testimony.
A lot of the passages just seem to relate to him saying, I think I have a duty. And if we disagree that one of the parties' views of the law establishes what the law is, but even assuming there's a duty to take care of things that he should have known about, I'm still struggling to know precisely what evidence you think creates an inference that the step was defective.
Well, the photographs that we supplied and which were ignored by the trial court show the steps not really looking in very good condition in the first place. Now, it's important, I think, that my clients, when they first moved in, never used those steps. They installed a stationary black gate right at the top of those steps so that their dogs would stay on that porch. So they used the other steps on the other side throughout their tenancy. The first time that Stacy Martinez ever stepped on that step was after they had moved all of their belongings out.
You're saying they didn't use the steps before they put the gate up? They never went up the stairs, never went into the house that way?
No, and that is what they testified. There was another entrance closer to where they parked their cars, and so that set of steps is what they used to come and go. We did provide a photograph of the stationary black metal gate, which they took down on the 29th of June, at some point when they were moving everything out. When they moved out, they actually extended a ramp from a U-Haul truck right up onto the porch itself, so thereby again avoiding those steps, and also, well, like I said, the very first time that Stacy used those steps was on the next morning when she went back on the 30th so that she could, clean the apartment or clean the house and retrieve, a few like small personal items. And so that was when the step broke. So certainly under normal circumstances, it could be argued, and certainly in a situation with a long-term lease, once the landlord turned that property over to my clients, then that they would have a duty to know what is going on with the property they're possessing. But especially in this case where the landlord knew that the gate was there. And
Are you saying the landlord's duty varies depending whether it's a long-term lease or a short-term lease or a month-to-month tenancy?
Well, not exactly, Judge. The landlord's, the duty varies based on whether it's a short-term lease versus a long-term lease. Yes, based on the present
Is there a duty at
case.
the end of the short-term lease to go inside and do a complete inspection of everything? Is the landlord month to month after the first month, okay, I've got to come in, test everything. I need to check everything in the bathroom, the kitchen, everything. Is that what the law is?
Well, I don't think so, Your Honor. The law says that the inspection has to be reasonable. So what a reasonable person would do. Now, reasonableness is a matter for the jury to decide, not for the trial judge.
But you're
So
saying
whether the trial
you're
judge-
saying reasonableness would be different if I'm the landlord and I rent something to someone for 6 months, as opposed to, I understand that you're probably going to stay for 6 months to a year, but we're going to do this month to month. You can let me know if you're going to leave. I can let you know if you need to get out. But so during those 6 months, under that scenario, if we just have a 6-month lease, as the landlord, I don't have any duty to do any inspection. It's on the tenant to let me know if there's a problem. But if it's a month to month, with the understanding that you're probably going to stay longer than a month, I have a different duty.
Not necessarily. I think it will depend on the facts and what portion of the property is in question. I mean, certainly the outside is certainly the landlord is not intruding upon the residents of the house by just looking around the property outside. So I think the duty does not change, except what is reasonable in meeting that duty, I think, is
Counsel, let me ask you a question that I think is going with what you're saying.
Yes.
Tell me I'm reading from Cummings v. Prater, which is a 1963 Arizona Supreme Court case. Tell me if this is the correct standard that a landlord owes to a tenant at the time the tenant takes possession of the property. It says the landlord is under a duty of ordinary care to inspect the premises when he has reason to suspect defects existing at the time of taking of the tenancy and to either repair them or warn the tenant of their existence. Do you agree with that so far?
Yes, I do.
That's the standard? Okay.
Yes, Your Honor.
In other words, he is under the duty to take those precautions for the safety of the tenant as would be taken under a reasonably prudent man under similar circumstances. That's what you're essentially saying, if I'm hearing you correct. Is that right?
Yes.
As the tenant
sir.
takes possession of the property, correct?
Yes, Your Honor.
Okay, now let me move forward. Once the tenant is in the property, in Piccola, I don't know if I'm saying that right, v. Woodall, which is a Division I case from 1996, it says the duty to inspect, so after the tenant is in, the duty to inspect arises when the landlord has reason to suspect a defect. Do you agree that that's the standard, when the landlord has a reason to suspect a defect?
That is not the sole duty when it comes to short-term leases. And in this case in particular, Your Honor, the landlord admitted at his deposition that he knew that he needed to check those particular steps.
So is your position that the landlord failed in his duty before the tenants, before the Martinezes took possession of the property, or that his failure was to the ongoing duty to inspect?
Well, we don't know, Your Honor. And so that's essentially because, since my clients never used those steps, had they used the steps on day one, maybe she would have fallen through on day one, and we would have no question about the duty or the application of the facts to the duty owed at that time. Since my clients never used those steps throughout the tenancy, we really can't know exactly when they,
When they were in a dangerous, defective...
when they started being dangerous.
Correct. Okay. So there's no record evidence before us that would say the steps were defective when the Martinezes moved into the property, correct?
Except for the photographs that were taken...
Those were taken later, correct?
At some point throughout the tenancy,
Okay.
which was approximately 6 months. And
Counsel, you have about 4.5 minutes left. So.
oh, well, thank you. If you have no further questions, I'll reserve the rest of my time then, if that's all right. Thank you very much.
Good morning. May it please the court. My name is Andres Chagoya, and I'm here on behalf of the appellee's cross-appellant, Mr. Hubert Scott Blake. At this time, since we do have a cross-appeal, I'll attempt to reserve 3 minutes of my time for rebuttal. The question in this case is simple. Can a landlord be held liable under Arizona law without notice? Does the duty...
So let me ask you a question.
Yes.
So what is the duty that's owed?
So the duty under Arizona law of a landlord to a tenant is, upon notice that a reasonable or a dangerous, unreasonably dangerous condition may exist, to perform an inspection. Then, if an unreasonably dangerous condition does exist, to repair or warn the tenant of the condition.
You're saying on notice from meaning that an inspection or the tenants call and say there's a problem?
Well, and that's a great question, Your Honor, because one thing that I think is being conflated here is the difference between a landlord's duty to a tenant and a land possessor's duty to a business invitee. Now, a business invitee, the land possessor owes an affirmative duty to inspect their property. However, that is not the case when it comes to a landlord and a tenant. A landlord only has to inspect when there is reason to suspect a defect exists.
And you're referring to after the tenant has taken possession of the property.
Correct.
And what case are you relying, when you relay what the landlord duty is, what's your best authority for that?
Absolutely. So Cummings v. Prater established the duty back in the 60s. However, Piccola, I believe that's how it's pronounced, I believe is the best case and the most relevant case at this time regarding a landlord's duty to a tenant. And in Piccola, they specifically say that the duty to inspect does not arise until there is reason to suspect a defect exists. And that's
There's evidence that the landlord did go to the property to collect rent. So there's evidence that he periodically was on the property. Does that make a difference in this duty analysis?
Absolutely. Well, it makes a difference in that that does not provide reason to suspect a defect exists. Again, whether he's on the property, not on the property, whether he's fixing other issues that may be on the property, what the court needs to look to, and I believe Proust v. Sambos also kind of reiterates this, is the notice has to be of the specific defect that is being claimed to have caused the injury, in this case,
But you would
the steps.
your reason to know might be something different than getting notice from a tenant?
Well, and I believe that the duty to discover the defect is different under reason to know than should know. However, the notice aspect has to be of the defect itself, because that is what the landlord would then need to
I guess I'm
inspect.
just not understanding the difference between notice of a defect. If he looks at something and he doesn't realize it, but a reasonable person would have concluded that there's a problem, that reason to know you're saying would be enough if it's something that's obviously a reasonable person would do something about. The landlord has an obligation to do something.
Absolutely, Your Honor. And that's the issue here. And I believe the trial court actually commented on that to this day, we still don't know if this step was defective or why it broke. There is no evidence,
But
no
doesn't that
admissible
put the tenant
evidence.
in a difficult situation since the step's been destroyed? How does the tenant prove her case?
Well, again, they have to show that there was notice of the defect. And the Piccola court actually said that if a defect does exist on the property, but the landlord doesn't have notice of it, even if the defect does exist, that there's no liability.
But you agree that beforehand, before the tenants move in, that the landlord has an obligation. If she moves in and on day one of the tenancy the step breaks, would you agree there's liability? Would the landlord have had an obligation to do something if all we know is the step breaks on day one? Are you saying there's still an argument that it was not unreasonable to know about the defective step?
Well, and again, I believe Cummings v. Prater actually kind of commented on that issue and saying that the landlord has a duty to inspect if he has a reason to believe a defect exists, even before giving tenancy and after handing over tenancy.
But if he has that duty, I mean, don't they sort of make their case saying, well, you had an obligation before we moved in, and we never used that. So it's not really much different than if we just fell on that step or the step broke the first day we were there. You agree as the landlord you had a duty to inspect and make sure that it was in a safe condition. You should have known about that step. The first time I stepped on it, it broke.
Okay, and
Would that be a jury question?
I would disagree in this case that is a complete analysis of the duty. Again, even before their tenancy, he only has to inspect if there is reason to suspect of a defect. It's not an affirmative duty to where he has to go through every part of the premises and make sure everything is safe. There's a difference, and a very important difference.
But I'm asking, though, if the very first day of the tenancy, the first time they step on the step, it breaks, wouldn't it be a jury issue about how reasonable your search for defects was if the step breaks the very first time someone steps on it? You're saying the landlord still would not be responsible if in looking at it he didn't see the defect?
Absolutely, and that's what Arizona law says, is that they would still need to provide evidence that a reasonable person would have looked at the step or in some way realized that a defect...
Would it be enough to say this looks like a really weathered step and I stepped on it the first time and it broke? That wouldn't be a jury issue?
I don't believe so, not to that point, Your Honor, because they would have to show that the weathered condition would normally have caused for the board to weaken or for some reason that it would have been a defect.
An expert to come in and say, the first time I stepped on this, it broke. There was something wrong with it that the landlord should have realized.
Well, and again, I think, that kind of points towards the Lowry v. Montgomery Cone case where they testified that, they argued the board is now gone and has been replaced after the incident, and so they couldn't actually test the board to see why it actually failed. But in Lowry, as that court pointed out, the plaintiff in that case had actually retained an expert that testified that this type of incident would not have occurred absent some negligence. And just to point on just a couple of things real quick that I believe is important to your question, the argument that this was the first time they ever used a step is wrong. That's not actually what both plaintiffs testified to, and which we cited in our summary judgment briefings. In fact, in Mr. Martinez's deposition testimony, he said, I asked, had you ever walked on those steps the entire time before you were moving out of the property? Probably when we were moving in. Okay, but after that, no. Were there any issues with the steps when you were moving in? No. And you never walked on them or noticed anything during the entire time you lived there, correct? I walked on them, but never noticed anything. That was Mr. Martinez. Ms. Martinez stated, so on the day of the incident, was that the first time you had ever used those steps? She answered, it would be the second time. When we first moved in, we used that area. Also, when we were moving in to move, and then we were moving out, it was the same thing. And in fact, she stepped on the steps, that exact step, moments before it broke, and there was nothing wrong with it. And she testified to the same, that when she stepped on it, right before coming back down and it broke, that she did not notice anything, that there was no reason.
And I agree that's compelling evidence that it's not immediately obvious. But if we're just hypothesizing here, this happens the second day they're there. They've walked up the steps once, the step breaks on the second day. Certainly the landlord would come in and say, well, you didn't notice it, so why should I have noticed it? But that wouldn't, you're saying that wouldn't be a jury issue either, just because the tenant didn't notice it walking up the stairs one time?
Again, it would be a jury issue if the tenant could provide evidence showing that a reasonable person would have looked or discovered that an inspection and a repair or warning was necessary. And that's the issue, and I believe that Cummings and
But aren't you agreeing that an inspection is necessary before you turn a house over to a tenant? You don't have an obligation to at least make sure it's reasonably safe before renting it out for the first time?
And I would agree that that's good practice, but we are focusing on the duty that is established under Arizona law, and in fact, he did perform an inspection prior to them moving out. And that's where I know...
Prior to them moving in?
Or moving in, I apologize, yes. Prior to them moving in, Mr. Blake did perform an inspection.
Can they make an argument, well, his inspection wasn't very thorough?
And they could if they had evidence to support that argument, but there is no evidence other than them saying the step broke. The step broke, therefore he didn't inspect.
And at what point would it be a kind of a racist if it happens the very first day of the tenancy?
Well, and again, when you look at res ipsa, of course, it has to be within their exclusive control, things of that nature. However, res ipsa wasn't pled in this case, and when you plead negligence specifically, you are limited to that pleading. However, the fact is this was 6 months after they moved in. It was not on the first day. It was not second day. And indeed, they used the steps on the first and second day and later on. This was 6 months or a little over 6 months after they had moved in. And as the Piccolo court stated, is that this duty owed by a landlord actually only exists until the tenants have a reasonable enough time to discover the defects themselves. 6 months is definitely enough time for them to discover these defects, if there are any, and to give notice and say there are repairs or there are defects that need to be addressed. However, that was never done, and both plaintiffs testified that there was never any notice or reason to believe the step was defective until it broke. But even then, we don't know why it broke. We don't know if it was because of a defective nature of the board. There's no way that we are able to say that at this time. So,
did you want to address the issues in your cross appeal?
Absolutely. Thank you, Your Honor. In our cross appeal, it is essential under Arizona law that when a contract does contain an attorney's fees provision, the trial court does not have discretion to deny attorney's fees. Now, the reasonableness, that is another issue, but to deny them when a contractual provision entitles a party to them, the court cannot deny those attorney's fees. Now, in the lease between the tenants and the landlord, it says that if suit be brought to collect rent or damages, that the resident will pay all costs to such action, including reasonable attorney's fees.
Is this a lawsuit to collect rent or damages?
And I believe it is, Your Honor. Damages is exactly what they're claiming here. Damages for the injury that plaintiff is claiming. Now, I know that on their response brief, their answering brief, plaintiff has argued that, no, that concerns damages to the property. However, the clause does say, or to collect the cost of repairs to or cleaning of the premises. And that alone, having those in the same clause, shows that the damages portion was not necessarily to address damages to the property. Otherwise, it would make the second term.
Bringing a negligence claim against someone, is that a suit to collect damages?
I believe so, yes, Your Honor. That is exactly what one of the counts in the complaint was for damages. And it's arising out of the tenancy which this contract governs. However, even if the court were to determine that this contractual provision does not apply here, the appellee, cross-appellant, is still entitled to attorney's fees because the plaintiff asserted a claim under the Arizona Residential Landlord-Tenant Act. Now, under that act, the only way, under Arizona law, that the duties that act actually governs can be applied is if there is a rental agreement, a contract, whether it be oral or written.
How was the claim resolved under the Landlord-Tenant Act? What was the ruling on that?
And it was dismissed. The claim under the Landlord-Tenant Act was dismissed. The entire case was dismissed at summary judgment.
Okay, but was that ever argued, something under the Landlord-Tenant Act? It seems like the whole focus here is on negligence on the part of the landlord. That seems different than typical claim under landlord-tenant law.
Right, and well, I know that the ruling doesn't directly address an analysis based on the Landlord-Tenant Act. However, as the court knows, the court needs to assume that the trial court took all of these issues under consideration and came to his ruling based on them.
Was that issue raised in the summary judgment briefing by either party?
Yes, we did raise some issues. As the court knows, this was initially a duty motion for summary judgment, and we did raise some of the issues regarding how the claim for the Landlord-Tenant Act was actually mimicked the premises liability claim in the complaint. So because the breach of the Landlord-Tenant Act was the same as the alleged breach of the premises liability claim, I believe that the court resolved both of those, since resolving one would be resolving the other at the same time. But that was raised in our initial argument on the motion for summary judgment.
But the statutory claim that you're referring to under the Landlord-Tenant Act, that's the same as the breach of the implied warranty of habitability.
That is correct, yes, Your Honor. And as the Ninth Circuit has actually determined in evaluating this exact type of case, where there is a negligence premises liability claim as well as a breach of the warranty of habitability, the Ninth Circuit has clearly laid out in applying Arizona law that a alleged breach of AirAlta requires an underlying contract. And in that case, they did award attorney's fees to the prevailing party because, again, under the Barmat and the Sparks analysis, the true analysis is whether or not the claim could have been brought in absent the contract. And in this case, it could not have. One, under AirAlta, a tenant requires an agreement, a rental agreement, a contract. If the tenant, in this case, was not a tenant and was just a person walking on the property, they would not be entitled to this duty that was alleged to have been breached. They would have been either a licensee if they were invited or a trespasser.
What if the argument is your negligence occurred before, you were supposed to inspect this before the contractual period began. You didn't do that. You're saying that still is a matter arising under contract. You were negligent. The very first day I move in, I step on a step and it breaks. The jury disagrees that I didn't do a good inspection previously as the landlord. But that means the landlord's entitled to fees from the tenant?
Well, again, under the discovery rule, it's when the negligence or the breach should be discovered. And whether he was negligent or not beforehand, if that were the assertion, the actual breach, the actual duty wouldn't have been owed until they moved in. So I would say yes, that if they did a breach under the warranty of habitability, even if it was a result of alleged previous negligence, that because the duty did not arise until the lease was signed and they were entitled as a tenant to enter the property, then yes, after that, if there were a breach or a claim of a breach, then yes, attorney's fees would apply to that as well. Now, real quickly, I know I only have a few minutes and I want to save something for rebuttal. Just to touch on a couple things that the opposing counsel had brought up. There was never evidence of a defect with the steps. The varmints, again, the testimony of Mr. Blake was that he would check under there for varmints, not that varmints nested under there. There was no current nest of varmints or anything that was happening. He did tighten screws on the steps. However, that was before the tenancy, and that goes to the previous inspection before they arrived. He checked them, and he actually tightened the screws, and they were fine. And so there was no evidence whatsoever that any inspection was necessary or that an actual condition or defect existed. And
You're
as
saying the screws on the steps or on the handrail?
it was on parts of the patio deck and the surrounding steps. He didn't testify that he checked on that exact specific step or the steps in that staircase. He said that I tightened some screws in the steps and the patio deck that they were attached to. Just got a little over a minute left, so I'd like to reserve that time for rebuttal. Thank you.
Thank you. Mr. Mazicchio?
Thank you, Your Honors. May it please the Court, I would like to address a few points made by opposing counsel, if I may, first. There is a question as to whether Stacy Martinez and Ed Martinez used the steps on the first day. I would like to make it as clear as possible that Mrs. Martinez did not testify at any point in time that she ever walked on that step. In fact, she said she didn't. She testified that she did the same thing on the first day moving in that she did on the last day moving out, which was to extend the U-Haul ramp over those steps, not walk on those steps, ramp right up to the door, thereby avoiding the steps. Mr. Martinez, who was also extremely inconsistent at his deposition, likely due to a bunch of health issues, he did not move anything into the property because he had just gotten out of the hospital after having heart surgery. He's not on the lease because when Stacy signed the lease, he was in the hospital after heart surgery. So by inferring from his testimony that he probably walked on that step on the first day, neither of them said that they definitely ever stepped on that step until Stacy fell through it on their last day. And if that can be inferred from his testimony, that inference is for the jury, not for a trial judge.
When I read your brief, I was understanding your position to be that it's the landlord's obligation to inspect during the tenancy. Did you make an argument that the landlord was negligent before they moved in, or was your focus on the landlord saying, I thought I had a duty? And so was your argument that he didn't inspect before, or from what I'm reading from your brief, that it was a duty to inspect after they moved in?
Well, both, Your Honor. We feel that whatever he did before they moved in.
But that was alleged. That was alleged and argued to the Superior Court that he didn't do a good inspection before they moved in.
I don't specifically recall that, Your Honor, because the initial motion was essentially saying that on day one, as soon as the tenants took possession, the landlord's duty ended. So the focus of those initial pleadings was really on the continuing duty, which extends throughout the tenancy under the Preston case. Now, I will say that whether the inspection prior to the tenancy or during the tenancy, whether the inspections and whether a reasonable landlord who admittedly is on the property all the time, lives across the street, mom lives next door, he testified that he did inspect the property and was always looking at the property.
Counsel, I
So
know
whether-
you're out of
yes.
time, but I have a quick question,
Yes.
just pivoting slightly. What happened
Yes.
to the breach of warranty of habitability claim? I didn't see it in the opening brief. You're not arguing anything with that on?
Well, that's really just an ancillary claim. This is a tort action, not a contract action. And for that reason, to stifle
Just quickly, because you're out of time.
Yes, I'm sorry. To stifle all future tort actions by making plaintiffs or would-be plaintiffs pay for the attorney's fees of the landlord, even if the plaintiff wins, is an illogical reading of that lease term.
All right, thank you, counsel. You are out of time.
Thank you very much. Thank you for allowing me an extra few seconds.
Mr. Chigoya?
And just real quick, since there's only a minute left, if there's any questions the panel may have for me that I could quickly address. All right, I don't know if that's a good thing or a bad thing. Well, the defendant would just ask then that the court affirm the trial court's grant of summary judgment, as well as the award of costs, and then also vacate their denial of attorney's fees and remand for a determination of reasonableness. And with that, I will let you go. Thank you.
All right, thank you. Counsel, thank you for your presentation. You have given us a lot to think about. We'll take the matter under advisement and issue a written decision in due course. We're adjourned.